All rise.
Please be seated. We're ready for argument in 2394, City of Houston against Rodriguez.
May it please the court, Ms. Martin will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, Mr. Chief Justice, and may it please the court. Our case is somewhat similar to the case that preceded us, so I wanted to jump right in and start talking about some of the issues that the court raised in the earlier discussion, specifically starting with Justice Bland's question about whether multiple acts of negligence can reach the standard for recklessness. And I think in answering that question, it's important to remember that recklessness is a subjective standard. Now, we've got two issues in our case, both the emergency exception and official immunity. In contrast to official immunity's good faith standard, which is an objective standard, the objective legal reasonableness of the officer's actions, recklessness is a subjective standard. And we've got two ways to reach that standard under Maspero. We've got the actual subjective knowledge of the officer in real time as he expresses in his affidavit. And in this case, Officer Corral was expressing that he was trying to drive as safely as possible under the circumstances as Officer Goodman, who was riding with him, was calling out the chase on the radio for both the safety of the officers as well as other motorists on the road. We also have the subjective, sort of the actions of the officer that can lead to an inference of recklessness. And this court's recent jurisprudence has sort of done a differential diagnosis, if you will, on that. What we know from Maspero and Crystal Green is that speeding and swerving alone are not actions that can lead to an inference of recklessness. We also know from Crystal Green that speeding, exceeding the speed limit in a way that the plaintiff described as very fast or at a high rate of speed, that kind of description by itself does not lead us to an inference of recklessness from the officer's actions alone. So, yes, there may be circumstances where multiple acts can lead to an inference of recklessness.
Like what kind of circumstance would you think would lead to an inference of recklessness aside from what we know is actually in the mind?
So I'm drawing parallels to the federal case law because the City of Sacramento versus Lewis, which I think this court also cited in Maspero, talks about, when you have a high-speed chase, we have to make sure we don't give the bad guys a playbook for how to avoid the chase. And in the federal side, there's only one or two cases that I can think of off the top of my head that reach recklessness. And one of them, and I think it's from the Fourth Circuit, but it doesn't cross my mind right now, talks about how a police officer wasn't responding to any situation, was just going home at the end of the day, and decided to flip on his lights and sirens and go at like 60, 70 miles an hour down a residential road.
What about the fact that the prior case had to do with gunshots being fired, whereas this really has to do with figuring out what was going on with a prostitution situation? And, of course, there was a chase because people were trying to escape. So are you saying that when you have a high-speed chase, no matter what the underlying cause is of what they're trying to figure out, that that's going to be a factor in favor of determining that it's an emergency?
I think you always have to consider the underlying circumstances for the need of the emergency. And I think that's consistent with what this court said in Maspero, that we have to weigh the needs and the risks. this is also part of the good faith analysis for official immunity. And
So for example, if the underlying thing that was being investigated, say, is, I don't know, some type of traffic violation, but then the person that is being alleged to have violated the traffic law is fleeing, would that be the same as if it were a response to gunshots or something else?
No, I think not. I think not. And what we have in this case, we have something other than just the misdemeanor prostitution investigation. We have a felony evasion with a motor vehicle, and then we also have the underlying felony of car theft because the individual had stolen a car earlier that afternoon. So when you've got, two felonies and a misdemeanor, we're elevating this beyond a broken taillight or a missed stop sign.
Before we get too far into the details, I want to make sure I understand your argument about the standard. You start off by telling us it is subjective. Then you articulated two things, the first of which sounded subjective, and the second of which sounded objective. And we have said in Martin, I think, for example, to recover, it's knew or should have known, and the should have known strikes me as objective. So reconcile all of that for me before you move on.
Right, and I think at the end of the day that we may want to reconsider Martin and eliminate the should have known element, because Maspero emphasized that we really do want to look at the subjective perspective of the officer, because again, at the end of the day, this is a limited waiver of immunity that we're talking about. And the emergency exception puts back in place that immunity that the motor vehicle waiver would otherwise waive.
Does that mean that we get rid of the second prong, the one where we're implying it? Like, how did you phrase it? We're seeing things by implication from the actions that were taken?
Infer recklessness from the actions. I think that's appropriate.
How is that not also, though, an objective standard that you just told us we should get rid of?
I think it is an objective. That's what I'm saying. I think if we're going to truly make this a subjective standard in accordance with the first part of what the court said in Maspero, we need to eliminate the or should have known from this part of this text.
But the inference you can keep, you think, even though that's not subjective?
No, that's what I'm saying. The inference from the court's actions is part of this court's jurisprudence.
Actions?
Yes, sorry. From the officer's...
We can be reckless too, there's no question. Yeah.
From the officer's actions is part of the court's current standard. But if we want to make this a truly subjective standard, we should get rid of the knew or should have, the should have known part, get rid of the inference of recklessness from conduct of the officer. And
that makes it pretty tough to even have a fact question about recklessness, doesn't it? I mean, if it's really just no person in a million people would do this, even officers in a chase, but this particular officer at that time didn't think that was really reckless. So, no fact question, out you go. Is that the consequence of the rule you're proposing?
Yes, and I think that's completely consistent with the statute itself.
But that's not the rule we apply in the punitive damages context, to require that you have direct admissions of reckless conduct from the defendant before we'll impose punitive damages based on a standard that's pretty much recklessness.
Right, but punitive damages don't apply to the government anyway. So we have our own kind of set of rules in the first place, and
but it's a recklessness standard that applies in the punitive damages context, essentially. And if this is also a recklessness standard, then why would the standards not be the same? I mean, there are very significant constitutional issues with imposing punitive damages, and so I wouldn't expect that recklessness would mean one thing in one context and something else in the other.
Right,
and yet we don't require direct evidence to support punitive damages of somebody saying, yeah, I just didn't care.
Sure, and yet at the same time, the Tort Claims Act has its own statutory underpinnings from common law and the punitive damages precedent.
So if in this case, the officer said, I was not reckless, I subjectively believed I did everything correctly, but there was evidence that the officer knew that the brakes hadn't been working. They hadn't been working for several weeks. And the officer got in that car and went on the patrol with kind of faulty brakes, and then engaged in a high-speed chase knowing that the brakes were not working well. are you saying that you couldn't infer from that evidence that he had an awareness of a danger and nevertheless proceeded with conscious disregard of the rights and safety of others? And that would seem like that would be inferring recklessness, but it would be from tracing the officer's knowledge and awareness of the risk to the rights and safety of others.
Sure, and in that situation, you wouldn't need to go to acts to infer negligence. You know what's in the officer's mind. If there is evidence that he did in fact know that the brakes were not working, and he chose to get in that car anyway, and he said, I knew the brakes were working, I chose to use this car, I knew that there was a chance that I'd have an accident while driving it during this pursuit, then you're on that first subjective standard anyway.
So then evidence that I know that, 2% of all these, lead to deaths and people, and 40% or 60% or whatever it is that we heard in the prior case lead to accidents in this. Like, I know that, if we can prove that he knew that, then are we in subjective land now, or is that objective?
I would say that knowledge could be in subjective land, but it wouldn't meet the standard anyway. Because if we're talking about 2%, the standard that this court talked about in Maspero is subjective awareness of extreme risk. 2%, some would say, is not extreme.
What if it was, I can't remember if it was 40% or 60% of police chases lead to a vehicular accident. What about that?
So that's where you get into some department policy issues and, big decisions made by departments and when chases are going to be allowed and when are not. These are not necessarily individual officer decisions. And so the Tort Claims Act, looking at an individual officer, we know that violation of department policy does not mean a violation of laws or ordinance that would override the emergency exception. So maybe we would also need to look at local laws and ordinances. For example, if a local ordinance says that because 60% of police pursuits lead to crashes, we are going to disallow police pursuits under these specific circumstances. But those are not, there's nothing in that on this record. What we have.
But if there were, you would think that would qualify as a subjective way to establish recklessness? Because you'd think that he would be charged with knowledge of the ordinance, or?
No, that would go to the other aspect of the test. We've got two avenues for the test.
Okay.
We've got the recklessness standard, and we've got violations of law and ordinance.
Okay, so you're only talking about the before the or for that?
Sure.
Part.
Yes.
Okay.
What about the official immunity defense? How is the standard for good faith different than the recklessness standard? Is it higher? Is it lower? Is it the same?
It's very similar, but it's removed, and I think it's more deferential and less subjective. And as this court said in Sauls, we need to remember that this is a standard of objective reasonableness. We are not looking at, we're filtering reasonableness through the lens of what the facts the officer knew at the time, but we are judging the officer's actions not in real time. We are not requiring the officer to consider the needs and risks in the moments before the collision. And so keeping that objective reasonableness and leaving good faith as a product of what another reasonably prudent officer could have believed in the moment is more deferential and more objective, and it doesn't get into what this officer believed he was doing right or wrong in the moment. I did also want to briefly, because I only have a couple minutes left, touch on the statutory construction issue that was hit in the earlier discussion about whether we only have 4 provisions in 546.01 that officers are exempted from. And I think what's really important to remember is that the court views statutes as a whole. We're not looking at isolated provisions. We're viewing it holistically and trying to make effect of every provision in the statute. And that means also viewing the waivers narrowly. And in that situation, we don't look at 546.01 as the only four criteria. We look at the emergency exception as being something that gives extra protection to a governmental entity so that their officers can act in the public good rather than having their executive prerogatives hijacked by litigation. And so if we view the statute holistically, there's no way to look at the emergency exception as incorporating only those four provisions of 546.01 as being the violations of the statute that are acceptable.
And if we rule for you on official immunity, we don't even have to touch that in your case, I take it?
Exactly.
Okay.
Any other questions? Thank you, Ms. Martin. We'll hear from the respondents.
May it please the court, Mr. McAllister will present argument for the respondents.
May it please the court, Associate Justices, it's a pleasure to be in front of you. It's my first time, so I'm a little nervous, as they say on TV. The facts of this case are unique to this case, but I guess you might say that about every case, but Officer Corral was involved in a high-speed chase. He was a backup for a prostitution sting. And I guess when they came out and said, "You're under arrest," the suspect took off, and Officer Corral went after him. In the process of chasing him, they determined somehow that the car was a stolen car. So the evading arrest is the state jail felony that I'm familiar with, and not personally, but as a lawyer. And prostitution is a Class B and a Class B misdemeanor. It was at the time. I think it's up to a state jail now. And the motor vehicle, theft of a motor vehicle, again at the time was a Class A misdemeanor, I believe. But once you start running away, then you got evading arrest, and so that's the felony. His affidavit narrates the chase, and it's an in and out thing. They get him over there. They're on Beltway 8 and Highway 59. I don't know if you're familiar with Houston at all. There's a Subaru dealership right on the corner, and somehow they get all tangled up chasing through this Subaru dealership. They go in and out and back and forth. And then the suspect exits the Subaru dealership and heads down the feeder road with the officer in close pursuit. Now, my understanding when I took the officer's deposition, he was in the middle lane. I'm not sure exactly why that was, chasing a suspect, but when the suspect made the sudden right turn, and I guess he was in close pursuit, very close to him, he missed the turn. The officer missed the turn initially. And so what he did was, at that point, he made a wide turn, and there's some speculation from the Court of Appeals about what he was actually doing. I don't know if any of that is accurate. He was going to go through the parking lot, and then he was going to, I don't know. Well, I haven't gotten any of that in deposition. I didn't see any of that on the affidavit, exactly what was in, at that point, what he was going to do after he made the decision to make the wide turn. But the wide turn took him past the street. And so when he came, he ended up past the stop sign where the appellees are sitting stopped at the stop sign. He states in his affidavit that he saw the appellees there at the stop sign as he was making the turn. Before, during, I don't know. But then he says he goes and he hits the curb, and his brakes, he didn't say his brakes failed him, he says his brakes didn't work. It's interesting, Officer Lee's affidavit, who also did the affidavit in this case, he doesn't mention that. So then he continues on, and he misses, there's a stop sign here. Somehow he misses the stop sign and goes and hits my client's, stopped at the light, stopped at the stop sign, but he hits him right in the back of their truck. It's a very hard impact. On the police officer questionnaire that he filled out 2 days after the accident, he states that he was going, at the time of the impact, he was going 35 to 40 miles an hour at the time of the impact. He also states on the questionnaire, they ask him if this is just a standard questionnaire that a police officer fills out after an accident. Did faulty equipment cause the crash? No. He checks no. Describe in detail how the crash occurred. It's different from his affidavit. Assisting vice undercover operation, driver of the vehicle attempted to something of the female undercover officer for sex. I then attempted to stop the driver from prostitution arrest, for prostitution arrest. At that time, he fled in the vehicle, and at the time I found the vehicle to be listed stolen. During the course of the pursuit, the red Mercedes turned east on Forum West Drive. This is the place where the accident occurred. From Sam Houston Parkway. As I attempted to turn east on Forum West Drive, I observed a black truck traveling on Forum West. I made a wide right turn and hit the brakes, not, I always have trouble reading this, not wanting to strike head on with a truck. So He claims he hits the brakes this is 2 days after the accident. He claims he hits the brakes. He doesn't say anything about the brakes failing in this particular questionnaire. Not wanting to strike head-on with a truck at the time. I hit the curb, striking the bed of the truck, and was unable to stop.
So what of all of that, do you contend elevates this from a mere negligence case to either a recklessness case? And if it is a recklessness case, how the official immunity defense is not met here?
Well, because I couldn't get an exact speed limit from him at the time that this happened. Perhaps he didn't know, perhaps he wasn't watching, but he's in a high-speed chase. And he hits the truck who stopped at 35 to 40 miles an hour, so he must have been going pretty fast. He has to make a decision at the point where the suspect vehicle turns. He can see, I don't know what he was doing at the time exactly that happened or exactly where he was. He says he was in the middle lane. He missed the turn. So at that point, he has to make a decision as to whether or not he's going to pursue the suspect or not. And it's our contention that, I mean, he had some reasons for not pursuing the suspect, because number one, they didn't know who he was, and number two, it's a stolen car, so even if they find the car, they're not going to find him. But he doesn't talk much about the danger, because he knows that there's a truck sitting there with at least one occupant in it. So he knows ahead of time, he has reason to believe, well, he knows that there's a danger of injury if he makes this turn. And it's our contention that he not only lost control after he hit the curb, but well before he hit the curb. He had to make a wide sweeping turn like this, and the investigating officer gave him a ticket for a wide turn at the scene of the accident. So it's a question. It's a function of whether you're going to follow the guy or you're going to not follow him. And it's the risk of losing him versus the risk of injuring somebody that's in the car. And in this case, he chose to ignore the risk. They said there was, in affidavits, I believe, Lee's affidavit, his affidavit, said there was minimal risk of injury. How do you know there's minimal risk of injury? That was the only thing they said. They're supposed to put down more information in their affidavits about this particular, the risk of injury versus the risk of the suspect fleeing. They didn't put anything else down besides minimal risk of injury.
I thought they said, well, the skies were clear, the roads were dry, the traffic, at the time of the day, sort of Saturday evening, traffic was pretty light. And so it seemed at that outset, all right, this is not terribly risky compared to other risks that we might find in different circumstances if each of those were different. On the other hand, you have a suspect who I think you mentioned is unidentified, but they knew had committed multiple felonies, is driving the wrong way down one-way streets. You know, if we're trying to determine for for the official immunity analysis, whether this is good faith, which in turn is objective legal reasonableness, why is it that that balance, it's your burden, I think, to displace that. Why is it that you can displace that, raise even a fact question about whether or not that was objective legal reasonableness that was displayed by the officers?
Well, he's going at a very high rate of speed when he has to make the sudden decision. And
Which is inherent in all chases, right?
of course, but he also knows that he knows, regardless of what he says on his affidavit, he knows there's a high risk of injury in making this turn. Not a minimal risk of injury.
That again sounds like we would say that probably about all chases. There's a risk of injury. That's, you're exempt from some of the traffic rules. We only allow trained people to do that precisely because we wouldn't let one of us do it. We're going to cause harm. We hope that police won't. Sometimes it happens, but does that make it something that is unreasonable inherently? That's what I'm trying to find out from you.
Well, he's got to make a decision at that point what to choose. What is the pathway from there? Whether he's going to follow, whether he's going to try to accomplish this wide turn, which, by the way, he couldn't have made if his brakes weren't working. And the reason I come back against the Court of Appeals with the brakes not working, it occurred to me that if suddenly the brakes aren't working, then he's not responsible. But the brakes were working. So he's not going to be able to make that wide turn without some brakes.
So you agree that the brakes were working, and if that's the only thing that the Court of Appeals really hung its hat on, is that not? If you agree that the brakes were working, and he said that, I think, as well. He sort of said, well, yeah, they're not working, but he clarified it. Well, clearly the brakes didn't stop you, but were they working? And he answered, yes, they were working. I think you've just agreed with that.
Right.
If the Court of Appeals says, well, the basis for our decision is the brakes weren't working, and both sides aren't really saying we agree with that, isn't that by itself enough reason for at least sending it back?
Well, that's exactly right. There's still a fact issue with regard to the reasonableness of his actions.
Of the split-second choice to do this instead of that?
Exactly.
But isn't that split-second choice the very thing, though, that we're not trying to penalize when they have to make it, as long as it is not objectively unreasonable? And the very fact that something happened, unfortunate, but why does that make it objectively unreasonable in light of the circumstances about this fleeing suspect?
I think given the high, I'm sorry.
No, please.
Once I get going, I have to go ahead and go. So I think that because of the high speed that he was going at the time, and the fact that he was going to have to make a wide turn, and the fact that he had no place to land, he missed a turn. So he was going into uncharted territory. He was going into a parking lot. He was going into an island with a stop sign in it. I mean, there was a car sitting right next to it. There's a lot of room for havoc here, and I think that's also an objective decision that the officer has to make quickly, very quickly. But all the factors, and he's an experienced officer in this area, but all the indications here was that he made the wrong choice. He couldn't, when he made his wide turn, he didn't know where he was going.
Does that sound like a momentary lapse in judgment?
Well, it's the only. Well, it was a critical lapse in judgment. I mean, momentary meaning regularly occurring in chase scenes? No. I think because of the fact that the car was sitting there and that he was going fast and that he had no place to go, really no place to go. He didn't know. He just knew he was chasing I guess he was gonna make it up as he went along. So I don't think it was a momentary lapse of judgment. Well, I think that's the basis of our argument here. I mean, that a reasonable police officer in a similar situation would have made a different decision. I just can't believe that the fact that he missed the turn, he couldn't, why couldn't he, I never have figured out why he couldn't just stop the vehicle and back up and go and continue his chase. That he figured that the only way to catch this guy was to make an illegal wide turn, dangerous illegal wide turn, that ends up striking the vehicle. So I think it's a question of reasonableness also. That yes, you have to make split-second decisions, but there's some split-second decisions that you have to make that are much more critical than other split-second decisions. And you have to, if you're going to drive a police vehicle, you have to be responsible for that. Being able to make split-second decisions and being able to decide when this is a good thing to do or this is a bad thing to do. In this case, I think it was a bad thing for him to do.
Any other questions? Thank you, Mr. McAllister.
Thank you. I never know where to put this. They don't have hangers for this thing.
Martin, you have 5 minutes.
I'm going to focus on my last two comments on the official immunity side of the case. And first of all, I did want to point out that the crash questionnaire that counsel was reading from is available in the record at CR 95. Counsel stated during his argument that our officer made the wrong choice. And this court said in Sauls that officers need to have freedom when they make split-second judgments like Officer Corral did in this case. The court also said in Telthorster that official immunity protects officers whose decisions were reasonable when made, but can be viewed unreasonably with the benefit of hindsight. And I think at this point, that is the most you can say about Officer Corral's decision to make a wide right turn in pursuit of the suspect. If he made the wrong call in the heat of the moment, he is protected because he tried his level best to drive safely, maintain a safe distance behind the suspect vehicle without getting too far that he couldn't catch up, but also stay far enough away that he wouldn't run into him or have an accident with the suspect. We also see that he used his emergency equipment throughout this pursuit, including his lights and siren, which were activated continuously. And at some point as they were leaving the Subaru dealership, he activated his air horn to make sure that the vehicles traveling on the access road saw him and yielded to his emergency vehicle before he proceeded onto the access road. And against these factors and the fact that the weather was clear and the roads were dry, traffic was light to medium, he and Sergeant Lee opined that another reasonably prudent officer could have believed these actions are justified. There was no controverting evidence. And in fact, in the trial court level, official immunity was conceded. So good faith was conclusively established, and even if Officer Corral made the wrong choice in the moment, he is still protected by official immunity, and the city of Houston's immunity is not waived. If there are no further questions, I'll yield the rest of my time.
I have a quick question.
Yes.
What about the choice to decide and to ensue in a chase for an alleged being back up in a prostitution sting case? Because it strikes me that a chase endangers the public, those people on the road, versus this prostitution issue, wherever that was at. Isn't that the key decision that has to be looked at?
It goes into, yes, it goes into the needs risk analysis, the Chambers-Waterwitz needs risk assessment. And, you know, at the time he initiated the pursuit, what was the need? At that point, all he knew was that this person had engaged in prostitution or attempted to engage in solicitation of prostitution. But as these things progressed, we learned that there were other factors in play, namely the stolen
But he
vehicle.
didn't have the benefit of some of that other information until he decided to pursue the chase.
Correct.
So he's placing the public at risk at large over a prostitution case
Yes.
that
he-
went haywire.
Yes,
at some
that is
point in
correct. And at the moment, he only had what he had. And he still tried to make a decision that another reasonably prudent officer could have made at the time. And in so doing, weighing the, you know, what ultimately turned out to be 2 felonies and a misdemeanor against the public risk. And without any controverting evidence to refute his good faith, we are left with official immunity shielding the officer and derivatively the city of Houston.
Any other questions? Thank you, Ms. Martin. The case is submitted, and the court will take one more brief recess.
All rise.